Judge Fletcher found no probable cause for the charge, concluding that there were insufficient indicators of intoxication to justify the administration of standard field sobriety tests, commonly known as SFSTs. Because field sobriety testing prolongs a traffic stop and creates a longer investigative detention, officers must possess reasonable suspicion that a driver has committed an intoxication-related offense before requiring such tests. In this case, the evidence was limited to the odor of alcohol and Ms. Rodriguez's statement that she had consumed 2 drinks, the last of which she finished 2 hours before driving. Based on these facts, Judge Fletcher ruled that officers lacked reasonable suspicion to extend the traffic stop for field sobriety testing under both state and federal case law, as well as Article 3823 of the Texas Code of Criminal Procedure. Evidence obtained through a constitutional violation, such as prolonging a traffic stop without reasonable suspicion, cannot be admitted against a defendant in a criminal proceeding. As a result, the field sobriety test results could not be considered. Judge Fletcher, therefore, concluded that no probable cause existed for the arrest, and the state ultimately dismissed the charge on October 28, 2024. The next probable cause hearing we will review also took place on November 4, 2024. Defendant Keon Shaw had been charged on October 28, 2024, with fleeing a police officer in violation of Section 545.21 of the Texas Transportation Code. That statute makes it a misdemeanor offense for a driver to willfully fail or refuse to bring a vehicle to a stop after receiving a visual or audible signal from a pursuing police vehicle.
Okay, Max, who do you have here?
Raquel Rodriguez.
Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then,
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the gyms, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the one leg stand. He also noticed that I think she took off her boots for the one leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accent here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per, you know,
But I get the
SFSTs.
SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. you understand?
Yes, sir.
Right. Please take a seat. You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27th, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
The officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure.
DMs.
Let's do this. I'm going to have them because I want to make sure if we find probable cause that it's really there. All right. So just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily. Okay. 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 So Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm going to find no probable cause.
Dismissing the case.
I know probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life. All right?
Yes, sir.
All right, man.
A Judge Fletcher again found no probable cause, noting that there was no specific allegation regarding how fast the driver was traveling to justify the initial traffic stop. Although the Texas Transportation Code does not explicitly require a traffic stop to be lawful, in order to charge someone with fleeing, constitutional protections still apply. If a stop violates the Fourth Amendment or Texas law, then, just as discussed earlier in this episode, Article 3823 of the Texas Code of Criminal Procedure requires that any evidence obtained from that stop, including an officer's testimony that the driver failed to stop, must be excluded from court. Under the Fourth Amendment, law enforcement officers may not stop a vehicle without reasonable suspicion supported by specific and articulable facts showing that a traffic violation or other crime has occurred. In the 2005 case Ford v. State, the Texas Court of Criminal Appeals rejected a traffic stop where the officer merely claimed the driver was following another vehicle too closely without describing the actual distance between the vehicles. The court held that a conclusory assertion of a legal violation without concrete details is insufficient to establish reasonable suspicion. Applying that precedent, Judge Fletcher concluded that the record lacked specific, articulable facts to support the stop, and therefore that probable cause for the arrest could not be established based on the admissible evidence. The state dismissed the charge the same day. The final probable cause hearing featured in today's episode took place on January 27, 2025. Defendant Francisco Cerda had been charged 5 days earlier, on January 22, 2025, with engaging in organized criminal activity in violation of Section 7102 of the Texas Penal Code. That statute makes it a criminal offense to commit, or conspire to commit, certain crimes with the intent to establish, maintain, or participate in what the law refers to as a combination, which Section 71.01 defines as 3 or more individuals collaborating in ongoing criminal activity. The statute applies to a wide range of underlying offenses, including drug trafficking, robbery, burglary, assault, murder, money laundering, and, as alleged in Mr. Serta's case, theft.
Asking your honor is Mr. Francisco Cerda. He's a custody judge, and I wonder if I'm wrong on this.
Is that C or an S?
The teacher, okay.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
My concern is, if you may, I want to bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this fuel. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
Remember, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
can you does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have at this time.
but I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because 7102. A person commits an offense if, with intent to establish, maintain, or participate in any combination or in the profits of a combination, or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS. But right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so and call the witness.
He's in custody, and I can't. If he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I would just need, I just need a little more time in order to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure.
Judge Fletcher found no probable cause because there were no specific allegations regarding Mr. Sid's conduct beyond his presence inside the stolen U-Haul. As the Amarillo Court of Appeals explained in the 2000 case Munoz v. State, to convict someone of engaging in organized criminal activity, the state must show that the defendant intended to establish, maintain, or participate in a group that agreed to work together in a continuing course of criminal conduct involving more than one crime or criminal episode. The court further held that mere presence during a single criminal incident is not enough to prove an ongoing agreement to engage in illegal activity over time. In Mr. Sid's case, prosecutors alleged only that he was inside the stolen vehicle. There was no evidence suggesting that he participated in more than one criminal episode or that the three defendants had entered into an agreement to carry out a continuing pattern of criminal conduct. As a result, Judge Fletcher ruled that probable cause was lacking, and the state dismissed the charge on February 24, 2025. These hearings highlight why probable, because determinations are such a critical safeguard in our justice system. When someone is arrested without a warrant, they are immediately deprived of their liberty, sometimes based solely on an officer's account. A probable, because hearing is often the first meaningful opportunity to test whether that arrest is supported by evidence capable of withstanding judicial scrutiny. Judges like Judge Fletcher, who carefully evaluate the record rather than simply rubber stamp arrests, help ensure that constitutional protections are applied in practice and reinforce the principle that government power must be checked. When courts find that probable cause is lacking, they not only protect the rights of the accused, but also strengthen public confidence in the fairness and impartiality of the justice system. If there's a case or courtroom moment you'd like us to cover next, let us know in the comments below. Thank you for watching. And don't forget to subscribe, share, and support our channel, Courtroom Clash, as we work to build a more informed society.